3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time we walked through the 2024 document releases. Today we are following Dodge 3.5 million cages through the documentary record so the timeline, decisions, and institutional failures are clear. As always, every document and source we reference is available at epsteinfiles.fm. So start with EFTA releases. That is where the paper trail becomes specific and testable.
It's the only place to start, really. If you want to understand the architecture of this case, the real architecture, not just the headlines, you have to look at the database itself first.
Before you even get to the names or the events.
Before any of that. We're talking about the Electronic Freedom of Information Act releases, the EFTA releases. This process creates a digital footprint that is legally supposed to be permanent.
Supposed to be.
It's meant to be the bedrock of government transparency. The fundamental principle is that once the government releases a document, it becomes part of the public record.
It's ours. It shouldn't just disappear.
It shouldn't. Once a file crosses that threshold from classified or sealed to public, it's cemented into the historical record. But when we audit the specific data sets released by the U.S. Justice Department, we find something else entirely.
A different story.
A story that's not about what's there, but about what was there and then wasn't.
You're talking about the forensic analysis of the file structure. And for you listening, this isn't speculation. We are looking at the Pinpoint database. Can you explain what that is? Because it doesn't sound like a government website.
It isn't. And that distinction is absolutely vital. Pinpoint is a third-party repository, a tool used by journalists and archivists to analyze massive data dumps.
So it's a shadow archive.
That's a perfect way to put it. When the DOJ releases files, they often come in these huge, unwieldy formats that are almost impossible to search effectively. Tools like Pinpoint ingest that data, they organize it, and crucially, they log the metadata.
They track what file exists and at what specific time.
It's like a surveillance camera pointed at the archive itself.
And what does that surveillance footage show?
It shows we have confirmed possession of datasets 1 through 8. Those are logged, they're hashed, they're available.
Okay, 1 through 8 are secure. We also have dataset 12.
We do. We can access dataset 12.
But basic math tells you something is missing in the middle there.
We're missing datasets 9, 10, and 11. They're either pending upload, which is unlikely at this stage, or they just don't exist in the public-facing directory.
Let's pause on that for a second. In a standard forensic audit of a major document release, and they claim this is 3.5 million pages, is a gap like that normal? Is it just an administrative error?
In a release of this magnitude and sensitivity, no. A sequential gap in dataset numbering almost always indicates a withheld tranche of documents.
What does withheld tranche mean?
It means those files were prepared, they were sorted, categorized, they were given a label, dataset 9. You don't label a folder 9 unless you have content ready for it.
Yeah.
So conceptually, the folder exists.
But it was pulled back before it went public.
It was pulled back from the final push to the server. So we have this hole on the digital shelf where volumes 9, 10, and 11 should be sitting.
But it gets stranger than just missing files. This isn't just about things that were never uploaded. We have documentation from the Pinpoint analysis that points to something more active, something you've called a deletion anomaly.
This is the critical piece. This is where that shadow archive proves its worth. The forensic analysis shows the DOJ began to release certain documents and multimedia files that actually went live on the server.
So they were up, publicly accessible.
For a window of time, yes. You could see them, you could download them.
Yeah.
And then they were gone.
Is that legal? Can they do that?
That is the core question. This is not how a government repository is legally supposed to function under the Freedom of Information Act. You don't release and then retract unless there's been a catastrophic redaction error.
Like if they accidentally left a social security number visible.
Right, or the name of a minor victim who hadn't been properly anonymized. In that case, you pull the file, you fix the redaction, you put a black box over the sensitive data, and then you re-upload it with a note.
But that's not what happened here.
No. These files didn't come back with more redactions. They just stayed gone.
Thankfully, third-party archivists, specifically the team at Courier, they intervened. They essentially scraped the site.
They hit save before the DOJ could hit delete functionally. They retained copies of these deleted items before they vanished from the official government domain.
So now we can look at the ghosts. We can see what was taken down. Does a pattern emerge from those deleted files?
A very specific one. This wasn't a random data corruption event. Among the items that were released and then methodically scrubbed by the DOJ were documents and files establishing connections between Jeffrey Epstein and former President Donald Trump.
We need to be very precise here. This isn't a political point, it's a data point.
Absolutely. We are looking at the metadata and the content. The files go up, the connection is made visible, and then the files come down.
From a forensic perspective, what does that establish?
It establishes a pattern of release and retract within the institutional record-keeping process. It suggests an active, ongoing curation of these files, even after they're technically public. It introduces a variable of unreliability into the official government source.
It means we can't fully trust that the official library is complete. For you trying to follow this at home, it's frustrating. It's a kind of institutional gaslighting. You didn't see that file.
Yes, I did. No, look, it's not there anymore.
Right.
That's why the distinction between the different sources of these files is so important. You have to know which bucket you're looking into.
Right. Let's separate the buckets for everyone. We're talking primarily about the U.S. Justice Department's Epstein files.
Yes, that's the 3.5 million page tranche that's under audit. That is completely separate from the Epstein estate files.
Tell us about the estate files.
That's a different collection, about 20,000 files. The estate files are corporate records, property deeds, maintenance logs for the island, private business records that became part of the legal proceedings after his death.
But the DOJ files?
That's the investigative record. That's the FBI interviews, the surveillance logs, the police reports. And the investigative record is precisely where we are seeing these gaps, data sets 9 through 11, and these active retractions.
So the business records are more or less intact. We know what he paid for the palm trees on Little St. James.
Exactly.
But the records of the investigation, the files about who was watching him and who he was trafficking victims to, those are the ones with holes.
The money trail is clearer than the justice trail.
Let's move to what we do have, the documentary record that did survive the scrub. Because even with the deletions, there is a mountain of public evidence. We're looking now at the release of the 2015 court documents related to Ghislaine Maxwell. These were often called the Powell's files.
The 2015 tranche is vital. It moves the entire narrative from speculation to corroboration. For years, this story just lived in tabloids and rumors. You'd hear, oh, I heard so-and-so was on the island. But that's not evidence.
It's just hearsay.
The 2015 court documents, especially when combined with the flight logs, provide a documentary lock.
When you say lock, what does that mean? It puts a person in a room.
It puts them at a specific coordinate in space and time. We start seeing corroboration for names that have been rumored for years, including Prince Andrew, Alan Dershowitz, and former President Bill Clinton.
Let's talk about the flight logs. The phrase the flight logs gets thrown around a lot. People say, release the flight logs, as if it's some single neat document. What are we actually looking at?
It's a very messy analog reality. These are pilot logs. They're handwritten entries from the pilots of the Lolita Express, Epstein's private Boeing 727, and his other aircraft.
And they list what? The date, departure, arrival?
And the passengers.
Yeah.
But when we talk about corroboration, it means cross-referencing these logs with other data points.
The flight logs are the primary documentary source.
They place specific people at specific locations at specific times. But here's how you build an actual case from that. If you have a flight log placing a subject on the plane with Epstein flying to the Virgin Islands.
Okay.
And then you have testimony from a victim placing that same subject at the villa on the island on that exact same date, now you have a corroborated timeline.
It's triangulation.
It is. And that's what the 2015 documents started to solidify. It took the names out of the gossip columns and put them squarely into the legal record.
But the timeline of these documents also forces us to look backward. These files came out in 2015, but the crimes were happening in the early 2000s. We have to look at why it took so long. We have to look at the 2008 plea deal.
The plea deal is the Rosetta Stone for this entire cover-up. It's the key.
We have Julie K. Brown's groundbreaking reporting on this. She called the deal a perversion of justice.
And legally, she's correct. It wasn't just a bad deal, it's a structurally broken one. The 2008 plea deal contains an anomaly that is almost unheard of in the American justice system.
Explain that anomaly.
It's the non-prosecution agreement, the NPA. Usually an NPA is a tool prosecutors use to climb the ladder of a criminal organization.
Right. You catch a low-level guy.
You catch a low-level drug dealer, you give him an NPA immunity, And in exchange, he gives you the name of his supplier. You give the little fish a pass to get the big fish.
But in this case, Epstein was the big fish. He was running the whole operation.
He was the head of the snake. And yet the NPA was structured to shield not just Epstein, but, and I'm quoting, any and all potential co-conspirators.
Any and all. That language is stunningly broad.
It's breathtaking. It effectively immunized the entire network. It meant that if you were a famous politician, a well-known scientist, or a foreign royal who had used Epstein's trafficking services, this single document signed in Florida protected you from any federal prosecution.
It's a get-out-of-jail-free card for the entire client list.
That is literally what it was. And that was an institutional decision. That wasn't a typo. It wasn't a clerical error where someone copy-pasted the wrong clause into a document.
It was a negotiated term.
A negotiated term, accepted by the U.S. Attorney's Office. Alexander Acosta, who later became the Secretary of Labor, he's the one who signed off on this.
It created a legal black hole that swallowed the investigation for a decade.
It did. It froze the documentary record. It meant no new files were generated, no new indictments were written, because the federal government had contractually agreed not to look. They agreed to close their eyes.
And because they closed their eyes in 2008, the trafficking just continued.
It continued.
Yeah.
And evidence grew cold. Memories fade. Surveillance tapes get overwritten. The perversion of justice isn't just that Epstein got a slap on the wrist 13 months in a private wing of a jail with work release. It's that the entire investigation into his network was strangled in the crib.
Which brings us to the sentencing that did finally happen, years later. Ghislaine Maxwell, sentenced to 20 years for her role. The big question at the time was, where are the names?
This is what we call the audit gap. We have a conviction. A jury found her guilty. Ghislaine Maxwell was sentenced for participating in a sex trafficking enterprise.
Let's focus on that word, enterprise.
An enterprise, by its legal and economic definition, requires a marketplace. It's a business. It requires a supply side, the victims, the girls, and it requires a demand side, the clients.
So the conviction legally establishes that the supply side of this enterprise existed.
Correct. A court of law has ruled, beyond a reasonable doubt, that she trafficked victims. She procured them. She groomed them. But if you look for the corresponding indictments on the other side...
To the buyers.
To the buyers, the clients. The documentary record is a vacuum. It's empty.
It's a ledger with only one column filled out.
You've got it. There is a complete institutional failure to list, pursue, or prosecute the other half of the criminal transaction. You cannot have a trafficking ring with no customers. It's a logical and economic impossibility.
So the DOJ files show a conviction for the middle manager, Maxwell, but the client list, the demand side, remains totally invisible in the legal record.
It remains sealed, or worse, uninvestigated and unindicted. And this connects to a much broader issue of how the DOJ and the FBI handled sensitive data. We have to look at the FBI audit that was reported on.
This was the audit regarding searches of Americans' communications.
Yes. And this is important because it puts the incompetence argument to rest. It's easy to say, oh, the government is just slow and bureaucratic. But this FBI audit revealed 8,000 unjustified searches of Americans' communications in a single reporting period.
Unjustified meaning they had no warrant, no legal basis to be looking?
That's the Bureau's own term for it. We're establishing a pattern of data behavior here. On one hand, for the average citizen, you have 8,000 unjustified searches, an aggressive, proactive, almost ravenous use of surveillance power. They're looking at everything.
And on the other hand?
On the other hand, regarding the Epstein client list, a list of powerful individuals potentially engaged in the systematic rape of minors, you have a total vacuum of that same surveillance power or prosecutorial action.
So they're looking where they shouldn't be, and they're refusing to look where they absolutely should be.
That is what the data pattern suggests. It aligns with testimony from whistleblowers regarding FBI and DOJ abuses. The handling of sensitive investigations is not neutral. It appears to be directional. The institutional silence on the Epstein client list is just as significant as the noise from those 8,000 unjustified searches.
It suggests the system is incredibly efficient when it wants to be, and conveniently broken when it needs to be.
Broken by design is a term some would use.
Let's apply that same lens, that directional handling of evidence and procedure, to the timeline of Epstein's death itself. Because if the plea deal was the shield, his death was the final escape hatch. We need to reconstruct the night of August 12th and 13th, 2019. This is the custody failure.
The custody failure is a sequence of institutional breaches. It's not one thing going wrong. It's a cascade of protocol violations that, when taken together, defy statistical probability.
Start with the personnel. This is the Metropolitan Correctional Center, the MCC, in Manhattan. Is it supposed to be a fortress?
It is. It's where they held El Chapo. It's where they keep high-level terrorists.
Well, it is.
But, citing sources briefed on the investigation, we know that one of the two people assigned to monitor Epstein in the special housing unit that night was not a regular correctional officer.
A fill-in.
A fill-in guard. This could be a secretary, a teacher, a facilities manager, someone who is not a trained guard, pulled onto a shift because of supposed staffing shortages.
Hold on. You have the most high-profile, most connected prisoner in the entire American justice system.
Yeah.
He has already had a previous suicide attempt, or at least a suspicious incident, just weeks prior. And the official staffing roster relied on a substitute who wasn't a regular detention officer.
That's the first major anomaly.
Yeah.
A regular guard knows the rhythms of the block. They know the sounds. They know when an inmate is acting differently. A fill-in is just trying to survive the night. It introduces a massive blind spot right into the security grid.
Then there's the check log. The official protocol is a visual check every 30 minutes.
That's the standard for Suicide Watch, or even just special housing protocol. The documentary evidence, the logs themselves, were falsified. They suggest Epstein had not been checked on for hours leading up to his death.
Hours. Not a mischeck or two, but hours.
Hours. The 30-minute interval is the primary safety mechanism. It was completely abandoned. And not by just one person, but by the entire shift.
And the cameras, the famous story of the malfunctioning cameras.
In a high-security federal facility, cameras are redundant. There are overlapping fields of view. If one camera goes down, another one covers that angle. For the camera specifically covering his cell to fail at that specific time, at the same time as the staffing failure, at the same time as the failure of the check logs.
The odds are astronomical.
I'm saying that in any other forensic investigation, you wouldn't call that a failure. You would call it an opportunity.
And yet, despite this mountain of procedural red flags, the classification of his death was almost immediate.
That's the third point. The rapid official classification of the death is suicide. Typically, when you have a death in custody accompanied by falsified logs, failed cameras, and irregular staffing, the investigation would remain open and suspicious for months, if not years. You would treat it as a potential homicide until you could prove otherwise.
But not here.
The institutional decision here was to classify it, close the book, and move on. Despite the documented procedural failures right there in the facility's own records, it's a pattern. Every time we examine a specific node in this network, the jail, the court files, the plea deal, we find a special exception was made to the rules. A procedure was skipped, a log was ignored.
It suggests the system wasn't failing randomly. It was functioning perfectly under a different, unwritten set of instructions. Let's look at the institutions outside of the DOJ that were making similar kinds of decisions. The complicity wasn't just in the legal system, it was in the financial system. Let's talk about the MIT Media Lab.
This is about financial complicity. We have the public admission from Joy Ito, who was the head of the MIT Media Lab, regarding their acceptance of money from Jeffrey Epstein.
And this wasn't just a case of we took a check and didn't look at the name. There was an explicit rationale behind it.
The decision point is fascinating. The institutional justification internally was that taking his money was justified at the time.
What was that moral calculation?
The argument was a utilitarian one. This man is bad, but his money can be used for good. They convinced themselves that the scientific progress they could fund with his capital outweighed the reputational risk or the moral stain of where it came from.
But that decision establishes a direct financial paper trail between Epstein and one of the world's most prestigious academic institutions. It launders his reputation.
Exactly. It legitimizes him. He buys the cover of a philanthropist. When he walks into a room at that level, he's not Jeffrey Epstein, the convicted sex offender. He's Jeffrey Epstein, the benefactor of MIT. It gave him cover. It gave him access to a new stream of power and influence.
And the institution decided that the money outweighed the risk. Or rather, they calculated that the risk was manageable, that they could keep it quiet.
Until the story broke. Then suddenly, the money became toxic. But their own internal files show they knew who he was. They went so far as to anonymize his donations in their own records to protect the institution, not to reject the money.
There's also the intersection with the world of intelligence. We have the interview with Ari Ben-Menashe.
Ben-Menashe is a former Israeli intelligence officer. He went on the record discussing his path crossing with Epstein's.
What does that potential intersection tell us about the documentary record? This is where the whispers of Mossad or CIA begin.
It complicates the prosecutorial timeline significantly. If Epstein was operating at the intersection of private lobbying, finance, and intelligence work, potentially gathering blackmail, then his files aren't just criminal evidence anymore.
They become national security assets.
And that might explain the behavior of the DOJ, that release and retract pattern we discussed at the very beginning.
It creates a different category of classification.
It does. Intelligence assets are protected under a completely different set of rules than evidence in a sex crimes case. If his operation had intelligence dimensions, then the gaps in datasets 9, 10, and 11 might not be about protecting a client's name. They might be about protecting methods and sources.
So the dark matter, the missing files, might be classified for reasons that have nothing to do with protecting a specific politician and everything to do with protecting the spycraft itself.
It's a plausible working theory,
Yeah.
especially when you consider the deletion anomalies. Intelligence agencies often have scrub protocols that can override standard DOJ archiving procedures.
We see this pattern of obstruction elsewhere, too. It's not unique to the Epstein case. We have reports about how the department behaves when it wants to hold on to information.
The reporting from Catherine Herridge is a key precedent here. It details the DOJ secretly seizing the phone records of Associated Press reporters.
They went after the journalists.
They seized the records to control the flow of information, to find leaks. It establishes a precedent for aggressive information control. It shows the department is willing to use its power to monitor who is talking about its own operations.
And we have the procedural parallel with the January 6th tapes. Now, we are not relitigating that event here, but we are looking at the procedure of how evidence was handled.
The parallel is strictly procedural. In that case, we saw the withholding of 14,000 hours of video footage. The government argued it was for security reasons. But the mechanism is identical: the centralized control and withholding of the primary video evidence. In Epstein's case, the video outside his cell malfunctioned. In other high-profile cases, it's simply withheld. The result for the public is the same.
You can't see the primary source.
You cannot. Which brings up the two-tiered justice argument.
This argument suggests that the law is applied differently depending on who you are.
It does. There are reports that highlight this disparity. They compare the treatment of certain defendants versus others.
How does that forensic lens apply to the Epstein client list?
You apply it by observing the lack of movement. We have a list of names in the flight logs. We have victim testimony naming powerful people, but we have inaction. The two-tiered argument suggests that evidence is handled differently based on the target. If the target is protected, the evidence enters a kind of legal black hole. If the target is not, the evidence is pursued aggressively. The Epstein files appear to be in that protected tier.
So let's synthesize all of this. We're consolidating the audit. We have the pinpoint data dilutions on one side. We have the MCC New York log falsifications and camera failures on the other.
Combine them, you see a repeated, undeniable pattern. Physical evidence exists at first. The logs existed. The digital files existed on the server. The video feed existed.
And
then it is removed, deleted, or altered by an institutional decision maker. The log entry is faked. The video is declared lost. The dataset is pulled from the public server.
it's not just random incompetence.
Incompetence is random. Incompetence means sometimes you lose a file that hurts the prosecution, and sometimes you accidentally release a file that helps them. This is not random. The documentary record shows the failures always move in one direction.
Towards the suppression of the network's full scope.
Always. And those missing datasets, 9, 10, and 11, that the pinpoint database shows should exist.
That's the dark matter.
That is the dark matter of this investigation. The 3.5 million pages we are told exist likely contain those missing links. But as long as the DOJ controls the release valve, and as long as they retain the ability to release and retract, we are all looking at a carefully curated reality.
We have the flight logs, we have the depositions, but we don't have the institutional will to complete the map.
The map is largely complete. The indictments are what's missing. The documentary record proves the files exist. It proves the timeline of the death was impossible under standard protocols. The failure is not accidental. It is a documented series of institutional choices.
Next time. Who hasn't been charged?
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.